This is the essay review for wills. Looking at execution of wills and types of wills, you have an attested will, which requires a writing to be signed by the testator in the presence of two witnesses. Witnesses sign will, understanding that the instrument is testator's will. That's an attested will. You also have a holographic will. This is a will signed by the testator, and material provisions are in the testator's handwriting. Here, extrinsic evidence is okay to prove the testator's intent. Date is not required, but may present inconsistency or capacity issues. Execution of wills and interested witnesses. Unless two disinterested witnesses present, meaning they have no interest in the property executed through the will, there's a presumption that those witnesses secured whatever gift they do receive by wrongdoing. It's not applicable if the interested witness is a fiduciary, such as the lawyer drafting the will might be. In execution of wills and intent, the testator must have capacity, which means they must be greater than 18, able to understand the extent of their property, and know the natural objects of their bounty. And this means know their beneficiaries. And to, of course, know the nature of the act forming a will. Intent and insane delusion. This is where the testator had a false belief that was product of a sick mind. There is no evidence to support that false belief, and delusion affected the testator's will. The part affected by the delusion is invalid and will go to the residuary, or if it cannot be cured, the testator will be intestate. And intestate means that they will then have no will. Intent, execution of wills and intent, and you have fraud. This is representation of material fact known to be false by a wrongdoer for purposes of inducing action or inaction, and it does in fact induce that desired action or inaction. And you have, under fraud, you have fraud in the execution. In relation to wills, this is where the testator's signature is forged, where they're given a document that they believe isn't testamentary. You have fraud in the inducement. This is a wrongdoer's representation affects contents of the testator's will. Here only the affected part is invalid. An execution of wills and undue influence. A prima facie case of undue influence is susceptibility. So testator is susceptible to influence. There's an opportunity for them to be influenced. There is active participation in influencing the testator, and there is an unnatural result in the will. Undue influence and a presumption of undue influence. So that was prima facie case. Here there is a presumption of undue influence where there's a confidential relationship. There's active participation, so confidential relationship between the testator and the beneficiary. There's an active participation by the beneficiary, and the benefit is an unnatural result. Here only the affected part is invalid. We got a revocation of a will. You can revoke a will by executing a subsequent will, and revocation of the prior will can either be done expressly in the subsequent will, saying I revoke prior wills and codicils, or it can be implied by execution of the subsequent will, where the subsequent will totally disposes the testator's estate. Revival of a prior will. If the second will is revoked later, the first will isn't revived unless the testator manifests a specific intent to revive through oral statements at the time of the second will's revocation, or if a codicil revoking will number 2 so states that will number 1 will be revived. Revocation of wills and physical acts. It can be revoked by a physical act, such as burning the will, tearing it, canceling it, destroying it, and canceling would just mean crossing it out, or just physically destroying the will. Revocation of wills, physical acts, and interlineations. Interlineations are where you write within the will physically by your hand to cross out sections of the will. Here, those interlineations must satisfy the requirements of attested or holographic wills. Must be signed, material provisions in their handwriting for holographic, or witnessed for attested. Looking at components of wills, where you want to incorporate a document or something by reference. Here, there's a document or writing that is in existence when the will was executed. The document is clearly identified in the will, and the testator intended to incorporate the document into the will. And the intent to incorporate is assumed if it's a document in writing in existence that's clearly identified in the will. Components of wills and pour-over wills. This is where the testator divises all assets into an inter vivos trust, a living trust. This is valid through incorporation by reference, requires an independent signature, or compliance with the Uniform Testamentary Editions of Trust Act. And this requires that the trust be valid before or at time of will's execution. Looking at components of wills and codicils, these are additions. They modify, amend, or revoke the wills. So you draft a will, then you draft a codicil a couple years later. It's an addition or an appendix to the will. So it can modify, amend, or revoke the will. And the codicil republishes, which means it redates the will. Codicil's effect on revocation. The testator executed a will, then executed a codicil, then revokes the codicil. There's a rebuttable presumption that the testator intended only to revoke the codicil. If the testator executes a will, then a codicil, then revokes the will, again, there's a rebuttable presumption that both the will and codicil are revoked. Looking at interpretation of wills, a mistake in content. If the mistake in content is an omission, there is no judicial remedy because the courts will not rewrite a will. If the mistake in content is an addition, there is a remedy possible because the courts can just cross out the mistaken addition. Where there is a mistake in execution, there's no probate if no intent, unless reciprocal or mutual will, and that's between spouses. Looking at mistake in inducement, and this is interpretation of wills, mistake in inducement. There is no relief unless both mistake and what the testator would have done are expressed on a will. Looking at mistake in description, if it's a latent mistake in description, such as on the face, the will looks okay, you can introduce parole evidence to establish ambiguity and the testator's intent. If the mistake in description is patent, which means on the face the will is invalid, under the common law there is no remedy. Under the model code, you can use parole evidence, but we're going to focus on the common law. Looking at interpretation of wills and lapse, for a will to be valid or a bequeathment to be valid, the beneficiary must survive the testator. A lot of jurisdictions, however, have anti-lapse statutes. Here, under an anti-lapse statute, if the predeceased is testator's blood relative, and that blood relative leaves an issue, such as a child, then the issue will step into the shoes of the predeceased and take absent a contrary provision in the will. So the anti-lapse statute prevents the bequeathment from lapsing. Looking at ademption. And ademption is the doctrine to determine what happens when property bequeathed under a will is no longer in the testator's estate at the time of the testator's death. And in a will you have specific devises, which are unique things, such as a unique sports car that's devised. You have a general devise, such as you give $100,000. This is payable out of the general assets of the estate. Then you have a demonstrative devise. This is from a particular source. But for a demonstrative devise, if that source is not enough, it can come from general property. Then residuary devise is all of the leftovers. Looking at ademption in regards to these devises and ademption by extinction, this only goes to specific gifts, specific devises. If the testator doesn't own the specific property, then the specific gift is deemed by extinction, so they can't do anything about it. Looking at ademption by satisfaction, this is you may satisfy a general demonstrative gift. Requirements here are the will provides for deduction of the inter vivos gift. Testator declares contemporaneous writing that the gift is a satisfaction. Beneficiary acknowledges in writing the satisfaction, and the property is given in satisfaction is the same as the gift in the will. Distribution issues in wills. What passes? After acquired property, such as you draft a will and then you later acquire more property, after acquired property and increases during the testator's lifetime will go to the intended beneficiary. Where the increase is between death and probate, specific devises will go to the beneficiary. General devises do not get the increase. And then again, the general device is just payable out of general assets. Looking at intestate succession. Intestate means that you just don't have a will. Order of, if you do not have a surviving spouse and you die without a will, the order of succession is issues, children, parents, siblings, grandparents. Distribution, generally in intestate succession, there are two ways that you can distribute assets. One is per capita, and the other is per stirpes. In per capita, if the deceased has 3 children, each branch of the lineage gets 1/3 of the estate. That's under per stirpes. Under per capita, if the deceased has 3 children and only one child is alive, that one child gets 1/3 of the estate. The remaining 2/3 of the estate will go to the next generation of his heirs and will be divided equally, so that 2/3 will be divided equally at the next level between all remaining parties. Adoption. Adopted kids are treated as natural kids in intestate succession. Intestate succession and non-marital kids, if it's a domestic partnership, non-birthing parent is parent if child is born during the domestic partnership. Or the non-birthing domestic partner is named on the birth certificate, or they make a voluntary promise to pay child support. Looking at intestate succession and advancement. This is an inter vivos down payment, so while living. So it's a down payment made while living, made by an intestate to the heir apparent. This is the same result as satisfaction. The intestate declares in writing that the gift is an advancement, and the heir acknowledges the gift is an advancement that will decrease their inheritance later after death. Simultaneous death, if the testator and the devisee, and this is in intestate succession and simultaneous death, if the testator and devisee die simultaneously, the devisee is deemed to predecease the testator. If this is in regards to a husband and wife, there's a simultaneous death, common property and qualified common property are divided in half. Simultaneous death in regards to life insurance, an alternative beneficiary, or the residuary. So it goes, if the husband and wife die, for example, and the beneficiary dies simultaneously with the holder of the life insurance, then it goes to an alternative beneficiary, or that asset goes to the residuary, which is all of the leftovers in the estate. The heir must survive for 120 hours to take. Rights of surviving spouse and children. If it's an omitted child and the child is born after testamentary instruments are executed and not provided for, the child will get an intestate share plus a share of assets in the trust, in any trust. An exception is for where the omission is intentional on the face of the instrument. So you specifically say Brent's not going to get anything, then Brent doesn't get anything. Can't take the intestate share. Rights of surviving spouse and children, and looking at the omitted spouse or domestic partner, this is the same as the child. But the exception is where it is intentional. So the surviving spouse would get an intestate share plus assets of anything in trust. Again, the exception is that the omission is intentional, or the spouse domestic partner is provided for in the alternative, or the spouse signed a waiver. relinquishing rights to inheritance. And that waiver must be a voluntary relinquishment of a known right, whether signed before or during marriage, and requirements of the waiver. It must be in writing, must have full disclosure of decedent's finances, independent counsel by the waiving spouse, and it's not invalid if the spouse had or should have had knowledge of finances, or if the waiver was in fact fair. No enforceability if the waiver is unconscionable, and that completes our review of wills for the essay.